Getting arrested for driving under the influence doesn't mean the investigation is over. After the arrest, police officers typically request that you take a urine, breath, or blood test to measure your blood alcohol content. You have the right to refuse these tests, but doing so usually leads to an automatic license suspension. Many people believe that a driving under the influence conviction requires test results showing your blood alcohol level. This is not true. You can still face conviction based on other types of evidence, even if you refuse to take a chemical test. Arizona enforces strict laws against impaired driving, and the penalties include possible jail time, significant fines, and a permanent criminal record. Arizona operates under an implied consent law. When you get behind the wheel in the state, you automatically agree to submit to chemical testing if law enforcement suspects impaired driving. Officers can request a breathalyzer test, blood test, or urine test after a DUI arrest. A breathalyzer measures your blood alcohol concentration through your breath sample. Blood tests analyze alcohol levels directly from your bloodstream. Urine tests detect substances in your system. Key testing facts. You consent to testing simply by driving in Arizona. Refusal triggers automatic penalties. Officers choose which test type to administer. Tests measure blood alcohol content and drug presence. If you refuse chemical testing, you face a 1-year license suspension for your first refusal. This penalty applies whether or not you're ultimately convicted of DUI. The state treats refusal as a separate violation from the actual DUI charge. Your blood alcohol concentration doesn't need to reach 0.08 to face charges. Arizona is a zero-tolerance state, meaning any impairment level can result in a DUI arrest. You can receive a DUI conviction even if you refuse a breathalyzer test or blood test. Officers rely on multiple forms of evidence to establish probable cause and prove impairment. Common evidence types: field sobriety tests, FSTs, performance officer observations during the traffic stop, physical signs of impairment, erratic driving patterns before the stop, slurred speech during conversation, bloodshot eyes, odor of alcohol on your breath or in your vehicle. Law enforcement officers document these signs of impairment in their reports. Their testimony about your behavior, appearance, and driving serves as evidence in court. Witnesses may also provide statements about your condition. A DUI charge in Arizona carries significant weight and can affect your finances, relationships, and career prospects. You need to act quickly to protect your rights and future. Contact a DUI lawyer immediately to review your case. An experienced attorney can evaluate the evidence against you and explain your options. Most law firms offer a free consultation where you can discuss your situation without any financial commitment. Your lawyer will help you understand whether you should contest the charges and request a jury trial. Negotiate with prosecutors for reduced penalties. Enter a guilty plea if that serves your best interests. During your free consultation, ask questions about the attorney's experience with DUI cases and their approach to defense strategies. This meeting does not create an attorney-client relationship until you formally agree to hire them. Time matters in DUI cases. License suspension deadlines and court dates come quickly, so getting legal advice early gives you the best chance at a favorable outcome. Contact the criminal defense team at 602-900-9891 to schedule your complimentary consultation.